Hello, everyone, and welcome to Uncivil Law. For today's case, we have a prison guard who was so bad, he went to prison. This is the case of United States of America versus Roderick Douglas. In this case, we get to learn about what a prison guard did, and he's very sad that he's going to jail for a long time. And he'd like to not go to jail for such a long time, if you please. And the Court of Appeals has to determine whether or not he gets to go to jail for a long time. So we're going to read this. Let's discuss. While serving as a corrections officer at the Richwood Correction Center in Louisiana, Roderick Douglas and 4 co-defendants came to suspect 5 inmates of being affiliated with gangs. The inmates were questioned extensively, but none admitted to a gang affiliation. Douglas, then a captain in the correction guard force, and his co-defendants took the inmates to an area of the prison with no security cameras. Always a good sign. The inmates were made to kneel while their hands were handcuffed behind their back. Douglas approached the first inmate and asked if he was in a gang. After the inmate repeatedly denied his involvement, Douglas sprayed the handcuffed inmate directly in the eye with pepper spray. Excellent. Douglas then approached the second inmate and made similar inquiries. In response to similar denials, Douglas likewise sprayed the pepper spray into the second inmate's eyes. So the beatings will continue until morale improves, I guess. Wow. So we've taken these 5 inmates to a back room where there are no cameras, and we are one at a time. Are you in a gang? No. Spray them in the eyes with pepper spray. Are you in a gang? No. Spray them in the eyes with pepper spray. That's great work. Way to go. Good. At this point, Douglas handed the pepper spray to one of his co-defendants. 3 of the co-defendants then took turns, spraying the remaining inmates in the eyes. As Douglas would later admit, each inmate was handcuffed, compliant, not posing a physical threat to anyone, and not evading or struggling at the time they were sprayed. So we weren't doing this because we needed to gain control. We were doing it just because we're sadistic. Excellent. No, you can't do that. You can't, in fact, just, torture a prison inmate for no reason. I seem to remember reading something about that in the Constitution once. Following this ordeal, the inmates were taken to a medical station for treatment. In an attempt to avoid suspicion, Douglas and his co-defendants filed false reports, alleging that it became necessary to use the pepper spray when, after questioning the inmates, one of the inmates attempted to escape with handcuffs on their knees. Good. According to these falsified reports, the remaining inmates were only inadvertently sprayed. I'm pretty sure the medical staff can tell the difference. While the officers attempted to subdue the inmate who was attempting to escape from a back room in the middle of the prison. Yeah. Douglas likewise lied about the incident when he later spoke with the warden and the facility. For these actions, Douglas and his co-defendants were charged in a 7-count indictment with offenses ranging from conspiracy to deprive civil rights to obstruction of justice. Yeah, we're guilty of many, many things. Many things. We are very horrible people. Us and our co-defendants have taken these people in the back room and sprayed them directly in the eyeball with pepper spray. So that's super positive. That's good news. Yeah. So having gone to trial and having convicted them, the pre-sentencing report determined that Douglas's conduct merited a total offense level of 30. Most recently here, this included a 4-level enhancement pursuant to law because the offense involved a dangerous weapon, a 3-level enhancement pursuant to law because the offense resulted in bodily injury, and a 6-level enhancement pursuant to law because Douglas qualified as a public official or was operating under the color of law at the time of the offense because he was a prison guard. Because Douglas had no prior convictions or adjudications, the resulting advisory guidelines was 97 to 121 months in jail. So under the advisory guidelines, this is what it recommended. Pursuant to law, the range was subsequently reduced to 60 months, the maximum 60 months, the statutory maximum punishment permitted under law. So, yeah, so there is an advisory range that says this is what you should do, but these particular offenses have a max. So it says, here's how much time we should give this offense, but unfortunately the statute doesn't allow for that. So the range suggested by the guidelines, because the guidelines are guidelines, the range suggested by the guidelines was 97 to 121 months. Unfortunately, the max we can give you is 60 months. That's the most we can give because of the offenses you were convicted of. So, let's do that. Let's give you the max. How about the maximum for you? We'll give you that. That sounds good. All right. And we're upset that we got the maximum, even though it was less than the suggested range. We shouldn't have gotten the maximum. We shouldn't spend 60 months or 5 years in jail because we're good guys. Good. Let's go with that. That sounds like a good plan. The court considered the defendant's statement during his allocution, which is where he admits to all these things, several letters filed on behalf saying that how he's a great guy, I'm sure, and previously filed requests for a downward variance before sentencing him to 60 months. The court then sentenced him to 60 months. This appeal followed. So the defendant said, I'd very much like to not be sentenced to 60 months in jail, please. And he had a whole bunch of letters said, he's a good guy. He shouldn't be sentenced to 60 months. And the trial court took a look at this and said, how about 60 months? Do you like 60 months? 60 months. That sounds like a good number. Let's do that. And he's appealing because he's sad. He's sad as 60 months for directly spraying 5 inmates directly in their eyeballs with pepper spray. All right, so the Court of Appeals has to figure out whether or not the trial court screwed this up somehow. So let's read that. On appeal, the defendant contends the district court erred in concluding he should receive a 4-level dangerous weapon enhancement, a 3-level bodily injury enhancement, and a 6-level public official or color of law enhancement. Because Douglas properly preserved his objection to the enhancements, we reviewed the application of the law de novo and the factual findings for clear error. Under these standards, the district court's application for each enhancement survives. So, yeah, we have to look at these guidelines. Now, incidentally, the guidelines are guidelines, and the district court can do anything within the range as long as it has cause. So even if the district court screwed up the guidelines, like the district court could say, you know what, how about the maximum? So even if the guidelines said, how about 12 months? The district court could say, how about 60? Do you like 60 instead of 12? Let's do 60 instead of 12. So the district court can do anything within the range. Now, if it deviates from the guidelines, it has to have cause. But, we're kind of there. So even if we screwed up the sentencing guidelines somehow, I'm not sure it would matter, but let's analyze whether or not we screwed up the guidelines. As for the 4-level dangerous weapon enhancement, whether an item is a dangerous weapon is a finding of fact that we review for clear error, which is a pretty high standard. The guidelines define a dangerous weapon as, among other things, any instrument capable of inflicting death or serious bodily injury. Serious bodily injury is defined as an injury involving extreme physical pain or protracted impairment of a function of a bodily member, organ, or mental facility, or requiring medical intervention such as surgery, hospitalization, or physical rehabilitation. In interpreting this language, several appellate languages have concluded that chemical agents can qualify as a dangerous weapon. So yes, a pepper spray may or may not be a dangerous weapon depending on the circumstances. So whether something is a dangerous weapon or not depends on a lot. Having sprayed directly into your eyeballs probably qualifies as a dangerous weapon, yes. After reviewing the current record, we similarly conclude the district court here did not err in finding the pepper spray satisfied these requirements based on the facts presented in this case. The record reflects that the pepper spray Douglas used, Phantom is the name of the pepper spray, is more potent than its usual pepper spray, and Douglas' own expert testified severe injuries are possible when pepper spray is deployed in close proximity, such as directly into your eyeball. His expert also classified pepper spray as a pain compliance tool. 2 victims who were treated in hospital after initial treatment in the prison infirmary, and one of the victims suffered protracted impairment in his right eye, some sort of permanent or at least quasi-permanent injury. In light of these facts, the district court's conclusion that pepper spray was capable of inflicting death or serious bodily injury was plausible. We're there. Consequently, the district court did not err in applying the 4 levels of dangerous weapon enhancement charge here. So yes, there may be some reasons to use pepper spray. The pepper spray may not be dangerous under all circumstances, but when you're doing pain for pain's sake and spraying it directly into their eyeballs, we're going to give you another 4 levels of enhancement for you. So pepper spray was a dangerous weapon under these conditions. Douglas' argument against the application of the 3 levels of bodily injury enhancement fares no better. We might have caused bodily injury. I didn't cause no bodily injury, he says. Let's find out. The district court's determination concerning whether a victim sustained a bodily injury within the meaning of the law is a factual finding, reviewing under clear error. The guidelines define a bodily injury as any significant injury. For example, an injury that's painful and obvious, or is a type for which medical attention ordinarily would be sought. We're there. Douglas' arguments against the enhancement mirror those made against a dangerous weapon. He argues, for example, the enhancement was inappropriate because pepper spray is not known to have lasting effects or cause a great bodily injury. If you're spraying it directly into their eyeball, probably. But under our precedent, application of the enhancement turns not on the actions, but rather on the injury sustained. Here, the district court did not err in concluding that the victim sustained a bodily injury within the meaning of the law. As outlined in the pre-sentencing report, each of the victims sought medical attention. At least 2 victims required follow-on treatment, with one of those victims requiring treatment after saying he couldn't see out of his right eye. Good times being had at this prison for sure. Next, we consider whether the district court erred in denying Douglas a request for a downward variance. Yes, he would very much like to not be sent to jail forever, or 5 years, whichever, is earlier. But yeah, he'd like to not go to jail for that long. And he said, please don't give me as much time. So he would like a downward variance. All right, let's consider that. As we made clear in a prior case, an unpublished decision, an allegation, the district court erred in failing to ground a downward variance amounts to a challenge to the substantive reasonableness of the sentence. Is it reasonable under these circumstances? Probably yes. We review such claims under abuse of discretion while simultaneously recognizing a sentence within a properly categorized range is presumptively reasonable. It's only not within the range because we literally could not give you that much time. So yes, it's not within the range because we literally were unable to give you as much time as you deserved. So the range suggested 97 to 121. The most we could give you is 60. So yes, it wasn't within the range because we couldn't. We really wish we could, though. We infer that judges have considered all the facts for a fair sentence. To rebut that presumption, the defendant must demonstrate a sentence does not account for a factor that should receive a significant weight. It gives significant weight to an irrelevant or improper factor, or represents a clear error in judgment. Under that framework, Douglas fails to demonstrate that he's within the guidelines that was substantively unreasonable. The district court expressly acknowledged its consideration of these arguments before imposing a 16-month sentence. Douglas is effectively asking us to reweigh the district court's calculus, which we will not do. We therefore conclude that directly spraying pepper spray into 5 inmates' eyes when those inmates are handcuffed and on their knees is a reasonable sentence, and therefore is affirmed. Thus, that brings us to the end of the case of United States of America versus Roderick Douglas. In this case, Roderick Douglas and his friends were guards in a prison system, and they thought that some people were in the gang. And they then brought these people into a back room with no cameras, and having handcuffed them behind their back and bringing them to their knees, one at a time, said, "Are you in a gang?" And then when they said no, directly pepper sprayed them directly into their eyeballs. And they were sentenced to 5 years in prison themselves for these horrible, horrible crimes, which almost doesn't seem like enough, but apparently that's what the law allows for. And they are very sad they're going to serve 5 years in prison because they don't think they deserve it. I think they do. I think having, taken people who are completely defenseless and handcuffing behind them back and bringing them to their knees and pepper spraying them directly in their eyeballs, I think that's a bad thing. I'm going to take a bold stance, guys. That's a sadistic and bad thing. Wow. I know, right? So, yeah, these people have to go to jail, and they have to be there for 5 years, and they deserve that, if not more, and that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.